the Democratic Republic of the Congo's Constitution of 2005 with amendments through 2011. Preamble. We, the Congolese people, united by destiny and history, encompassing the noble ideas of liberty, of fraternity, of solidarity, of justice, of peace, and of work. Animated by our common will to build, in the heart of Africa, a state of law and a powerful and prosperous nation, founded on a real political, economic, social, and cultural democracy. Considering that injustice and its corollaries, impunity, nepotism, regionalism, tribalism, clanism, and patronage, by their multiple vicissitudes, are at the origin of the general decline of values and of the ruin of the country. Affirming our determination to protect and to consolidate the national independence and unity with respect for our diversities and for our positive particularities. Reaffirming our adherence and our attachment to the conventions of the United Nations on the rights of the child and on the rights of women, particularly to the objective of the parity of man-woman representation within the institutions of the country, as well as to the international instruments concerning the protection and promotion of human rights. Moved by the will to see all the African states united and working in concert with a view of promoting and of consolidating African unity through the continental, regional or sub-regional organizations to offer better perspectives of development and of socio-economic progress to the peoples of Africa. Attached to the promotion of mutually advantageous international cooperation and to the rapprochement of the peoples of the world, with respect to their respective identities and to the principles of sovereignty and of the territorial integrity of each state, reaffirming our inalienable and imprescriptible right to organize ourselves freely and to develop our political, economic, social, and cultural life following our own genius. Conscious of our responsibilities before God, the nation, Africa, and the world, solemnly declare to adopt this Constitution. Title 1 of the General Provisions. Chapter 1 of the State and Sovereignty. Section 1 of the State. Article 1. The Democratic Republic of the Congo is within its frontiers of 30th of June 1960 a state of law, independent, sovereign, united and indivisible, social, democratic and secular. Its emblem is the sky blue flag decorated with a yellow star in the superior left corner and transversed on the bias by a red band finely outlined in yellow. Its motto is Justice, Paix, Travail. Justice, peace, work. Its coat of arms consists of the head of a leopard framed on the left, and to the right by the ivory tusk and by a spear, all of which rest on a pier. The national anthem is Debout Congolais, Arise Congolese. Its currency is le franc congolais, the Congolese franc. Its official language is French. The national languages are Kikongo, Lingala, Swahili, and Chiluba. The state assures their promotion without discrimination. The other languages of the country are made part of the Congolese cultural patrimony, of which the state assures the protection. Article 2. The Democratic Republic of the Congo is composed of the city of Kinshasa and of 25 provinces endowed with juridical personality. These provinces are Bauele, Équateur, Haute-Lomami, Haute-Katanga, Haute-Uele, Ituri, Kasai, Kasai Oriental, Congo Central, Kwango, Kwilu, Lomami, Lualaba, Kisai Central, Mai-Ndombe, Maniema, Mongala, Nord Kivu, Nord Ubangi, Sankuru, Sud Kivu, Sud Ubangi, Tanganyika, Chopo, Chwapa. Kinshasa is the capital of the country and the seat of the national institutions. It has the status of a province. The capital may only be transferred to another place in the country by way of referendum. The division of competencies between the state and the provinces is effected conforming to the provisions of Title III of this Constitution. The boundaries of the provinces and those of City of Kinshasa are established by an organic law. Article 3. The provinces and the decentralized territorial entities of the Democratic Republic of the Congo are endowed with juridical personality and are administered by the local organs. These decentralized territorial entities are the city, the commune, the sector, and the chefferie, headman's district. They enjoy free administration autonomy of management of their economic, human, financial, and technical resources. The composition, the organization, and the functioning of these decentralized territorial entities, as well as their relations with the state and the provinces, are established by an organic law. Article 4. New provinces and territorial entities may be created by division or by reorganization under the conditions specified by the Constitution and by the law. Section 2 of Sovereignty. Article 5. National sovereignty belongs to the people. All power emanates from the people who exercise it directly by way of referendum or by elections and indirectly by their representatives. No fraction of the people or any individual may arrogate its exercise. The law establishes the conditions of organization of the elections and of the referendum. Suffrage is universal, equal, and secret. It is direct or indirect. Without prejudice to the provisions of Articles 72, 102, and 106 of this Constitution, all Congolese of both sexes of 18 years of age at least and enjoying their civil and political rights are electors and eligible under the conditions determined by the law. Article 6. Political pluralism is recognized in the Democratic Republic of the Congo. All Congolese enjoying their civil and political rights have the right of creating a political party or to affiliate themselves to a political party of their choice. The political parties participate in the expression of suffrage, in the reinforcement of the national conscience and of the civic education. They form and exercise their activities freely with respect for the law, for public order, and for morality. The political parties are held to the respect for the principles of pluralist democracy, of national unity, and of national sovereignty. The political parties may receive from the state public funds designated to finance their electoral campaigns or their activities under the conditions defined by the law. Article 7. No one may institute in any form that may be a sole party on all part of the national territory. The institution of a sole party constitutes an imprescriptible infraction of high treason punishable by the law. Article 8. Political opposition is recognized in the Democratic Republic of the Congo. The rights connected to its existence, to its activities, and to its struggle for the democratic conquest of power are sacred. They may not be subject to limits other than those imposed on all political parties and activities by this Constitution and the law. An organic law establishes the status of the political opposition. Article 9. The state exercises a permanent sovereignty notably over the soil, the subsoil, the waters and the forests, over the air, river, lakes and maritime spaces of the Congo, as well as over the Congolese territorial sea and over the continental shelf. The modalities of management and of concession of the domain of the state specified in the preceding paragraph are determined by the law. Chapter 2 of Nationality. Article 10. Congolese nationality is one and exclusive. It may not be held concurrently with any other. The Congolese nationality is either of origin or by individual acquisition. Any person belonging to an ethnic group of which the members, personnes, and the territory are constituent to that which became the Congo, presently the Democratic Republic of the Congo, at independence, is Congolese of origin. Title 2 of Human Rights, of Fundamental Freedoms, and of the Duties of the Citizen and of the State. Chapter 1 of Civil and Political Rights. Article 11. All human beings are born free and equal in dignity and in rights. However, the enjoyment of political rights is recognized to Congolese only, save for the exceptions established by the law. Article 12. All Congolese are equal before the law and have the right to equal protection of the laws. Article 13. No Congolese person may, in matters of education or of access to public functions or any other matter, be subject to a discriminatory measure that results from the law or from an act of the executive, for reason of his religion, of his family origin, of his social condition, of his residence, of his opinion or political convictions, or his belonging to a certain race, to an ethnicity, to a tribe, or to a cultural or linguistic minority. Article 14. The public powers see to the elimination of any form of discrimination concerning women and assure the protection and the promotion of their rights. They take, in all the domains, notably in the civil, political, economic, social, and cultural domains, all the measures appropriate to assure the total realization and full participation of women in the development of the nation. They take measures to struggle against all forms of violence made against women in public and in private life. Women have the right to an equitable representation within the national, provincial, and local institutions. The state guarantees the implementation of man-woman parity in these said institutions. The law establishes the modalities of application of these rights. Article 15. The public powers to see the elimination of sexual violence. Without prejudice to international treaties and agreements, any sexual violence made against any person with the intention to destabilize or to dislocate a family and to make a whole people disappear is established as a crime against humanity, punishable by the law. Article 16. The human person is sacred. The state has the obligation to respect it and protect it. All persons have the right to life, to physical integrity, as well as to the free development of their personality, under respect for the law, of public order, of the rights of others, and of public morality. No one may be held in slavery or in an analogous condition. No one may be subjected to cruel, inhuman, or degrading treatment. No one may be subjected to forced or compulsory labor. Article 17. Individual liberty is guaranteed. It is the rule. Detention, the exception. One may only be prosecuted, arrested, detained, or sentenced by virtue of a law and in the form that it specifies. No one may be prosecuted for an act or an omission which did not constitute an infraction at the time it was committed and at the time of the prosecution. No one may be sentenced for an act or an omission which did not constitute an infraction of the law at the time it was committed and at the time of the sentencing. One may not be inflicted with a punishment harsher than that applicable at the time the infraction was committed. The punishment ceases to be executed when, by virtue of a law subsequent to the judgment, 1. It is suppressed. 2. The act for which it was declared no longer has the character of an infraction. In the case of reduction of the punishment by virtue of a law subsequent to the judgment, the punishment is executed in accordance with the new law. Criminal responsibility is individual. No one may be prosecuted, arrested, detained, or sentenced for an act of others. Any person accused of an infraction of the law is presumed innocent until his culpability has been established by a definitive judgment. Article 18. Any arrested person must be immediately informed of the reasons for his arrest and of any accusation made against him in the language which he understands. He must be immediately informed of his rights. A detained person has the right to enter immediately in contact with his family or with his counsel. Detention may not exceed 48 hours. At the expiration of this period, the person detained must be released or placed at the disposition of the competent judicial authority. Any detainee must benefit from a treatment which preserves his life, his physical and mental health, as well as all his dignity. Article 19. No person may be relocated or transferred against the will of the judge that the law assigns to him. All persons have the right that their case will be heard within a reasonable time by the competent judge. The right to defense is organized and guaranteed. All persons have the right to defend themselves or to be assisted by a defender of their choice at all stages of the criminal procedure, and including the police inquiry and the investigation before trial. They may be assisted equally before the security services. Article 20. The audiences of the courts and tribunals are public unless this publicity is judged dangerous for public order or morality. In this case, the tribunal orders closed audiences. Article 21. All judgments are written and substantiated. They are pronounced in a public audience. The right to recourse against a judgment is guaranteed to all. It is exercised within the conditions established by the law. Article 22. All persons have the right to freedom of thought, of conscience and of religion. All persons have the right to manifest their religion or their convictions alone or as a group, both in public and in private, by worship, teaching, practices, the accomplishment of rites and the state of religious life, under reserve of respect for the law, for public order, for morality and for the rights of others. The law establishes the modalities for the exercise of these freedoms. Article 23. All persons have the right to freedom of expression. This right implies the freedom to express their opinions or their convictions, notably by speech, print and pictures, under reserve of respect for the law, for public order and for morality. Article 24. All persons have the right to information. The freedom of the press, the freedom of information, and of broadcasting by radio and television, the written press or any other means of communication are guaranteed, under reserve of respect for the law, for public order, for morals and for the rights of others. The law determines the modalities of exercise of these freedoms. The audiovisual and written media of the state are public services, the access to which is guaranteed in an equitable manner to all the political and social movements. The status of the media of the state is established by the law, which guarantees the objectivity, the impartiality, and the pluralism of opinion in the treatment and diffusion of information. Article 25. The freedom of meetings, peaceful and without arms, is guaranteed under reserve of respect for the law, for public order and for morality. Article 26. The freedom of demonstration is guaranteed. All demonstrations on public roads or in the open air require the organizers to inform the competent administrative authority in writing. No one may be forced to take part in a demonstration. The law determines the measures of application. Article 27. All Congolese have the right to address, individually or collectively, a petition to the public authority which responds to it within 3 months. No one may be made the subject of discrimination in any form that may be for having taken such an initiative. Article 28. No one is required to execute a manifestly illegal order. Every individual, every state agent is relieved from the duty to obey when an order received constitutes a manifest infringement of the respect of the rights of man and of the public freedoms and of morality. The proof of the manifest illegality of the order is incumbent on the person who refuses to execute it. Article 29. The domicile is inviolable. Entry or searches may only be effected in the forms and the conditions specified by the law. Article 30. All persons who are on the national territory have the right to circulate freely in it, to establish their residence in it, to leave it, and to return it, under the conditions established by the law. No Congolese may be expelled from the territory of the Republic, or forced into exile, or forced to live outside his habitual residence. Article 31. All persons have the right to the respect of their private life and to the secrecy of their correspondence, of telecommunications, and of any other form of communication. This right may only be infringed in the cases specified by the law. Article 32. All foreigners who find themselves legally on the national territory enjoy the protection granted to persons and to their assets under the conditions determined by the treaties and the laws. They are required to conform to the laws and regulations of the Republic. Article 33. The right to asylum is recognized. The Democratic Republic of the Congo grants, under reserve of national security, asylum on its territory to foreign nationals, prosecuted or persecuted, notably for their opinion, their belief, their racial, tribal, ethnic, linguistic affiliation, or for their action in favor of democracy and for the defense of the rights of man and of peoples in accordance with the laws and regulations in force. It is forbidden that any person regularly in enjoyment of the rights of asylum undertake any subversive activity against their country of origin or against any other country from the territory of the Democratic Republic of the Congo. Refugees may neither be remitted to the authority of the state where they are prosecuted nor sent back to the territory, or the latter. In no case may a person be turned over to the territory of a state in which they risk torture or cruel, degrading or inhuman punishment or treatment. The law establishes the modalities of the exercise of this right. Chapter 2 of Economic, Social and Cultural Rights. Article 34. Private property is sacred. The state guarantees the right to individual or collective property acquired in conformity to the law or to custom. It encourages and sees the security of private investments, national and foreign. One may only be deprived of his property for reasons of public utility and in return for a just and prior indemnity conceded under the conditions established by the law. One may only have their assets seized by virtue of a decision taken by competent judicial authority. Article 35. The state guarantees the right to private initiative to both nationals and to foreigners. It encourages the exercise of small commerce, of art and of artisanship by the Congolese and sees to the protection and to the promotion of national expertise and competencies. The law establishes the modalities of exercise for this right. Article 36. Work is a sacred right and duty for each Congolese. The state guarantees the right to work, protection against unemployment, and an equitable and satisfactory remuneration, assuring the worker, as well as his family, of an existence in accordance with human dignity, together with all other means of social protection, notably retirement pensions and life annuities. No one may be discriminated against lesser in their work because of their origin, their sex, their opinions, their beliefs, or their socio-economic condition. All Congolese have the right and the duty to contribute through their work to the national construction and prosperity. The law establishes the status of workers and regulates the particulars concerning the juridical regime of the professional orders and the exercise of professions which require a scholastic or academic qualification. The internal structures and the functioning of the professional orders must be democratic. Article 37. The state guarantees the freedom of association. The public powers collaborate with the associations which contribute to the social, economic, intellectual, moral, and spiritual development of the population and to the education of the citizens, masculine, and the citizens feminine. This collaboration may take the form of a subsidy. The law establishes the modalities of the exercise of this freedom. Article 38. The syndical right is recognized and is guaranteed. All Congolese have the right to found trade unions or to affiliate with them freely under the conditions established by the law. Article 39. The right to strike is recognized and guaranteed. It is exercised under the conditions specified by the law, which can forbid it or limit its exercise in the domains of national defense and of security or for any public activity or public service of vital interest for the nation. Article 40. Each individual has the right to marry with the person of their choice, of the opposite sex, and to establish a family. The family, the basic unit of the human community, is organized in a manner to assure its unity, its stability, and its protection. It is placed under the protection of the public powers. The care and the education to be given to the children constitute, for the parents, a natural right and a duty which they exercise under the surveillance and with the aid of the public powers. The children have the duty to assist their parents. The law establishes the rules concerning marriage and the organizations of the family. Article 41. Every person, without distinction of sex, who is not more than 18 years of age is a minor. All minors have the right to know the names of their father and their mother. They have equally the right to enjoy the protection of their family, of society, and of public powers. The abandonment and maltreatment of children, notably paedophilia, sexual abuse, as well as the accusation of witchcraft, are prohibited and punishable by law. The parents have the duty to take care of their children and to assure them of their protection against any act of violence both inside and outside their home. The public powers have the obligation to assure protection to children in a difficult situation and to bring to justice the authors and the accomplices of acts of violence concerning children. All other forms of exploitation of minors are punishable by the law. Article 42. The public powers have the obligation to protect youth against any infringement of their health, of their education, or of their integral development. Article 43. All persons have the right to a scholastic education. It is provided by national education. National education consists of public establishments and approved private establishments. The law establishes the condition of creation and of functioning of these establishments. The parents have the right to choose the mode of education to be given to their children. Primary education is obligatory and free in the public establishment. Article 44. The eradication of illiteracy is a national duty, for the realization of which the government must elaborate a specific program. Article 45. Education is free. It is nevertheless subject to the supervision of the public powers under the conditions established by the law. All persons have access to establishments of national education without discrimination of place of origin, of race, of religion, of sex, of political or philosophical opinions, of their physical, mental, or sensorial state in accordance with their capacities. The national education establishments shall assure, in cooperation with the religious authorities, to their minor pupils, and have parents demanding it, an education conforming to their religious convictions. The public authorities have the duty to promote and to assure, through teaching, education and diffusion, the respect of the rights of man, of the fundamental freedoms, and of the duties of the citizens provided by this Constitution. The public powers have the duty to assure the diffusion and the teaching of the Constitution, the Universal Declaration of the Rights of Man, the African Charter of the Rights of Man and of Peoples, as well as all the duly ratified regional and international conventions concerning the rights of man and to international humanitarian law. The state has the obligation to integrate the rights of the human person into all the training programs of the armed forces, of the police, and of the security services. The law determines the conditions of application of this article. Article 46. The right to cultural, to freedom of intellectual and artistic creation, and that of scientific and technological research are guaranteed, under reserve of respect for the law, for public order, and for morality. Copyrights and intellectual property rights are guaranteed and protected by the law. The state takes into account in carrying out its tasks of the cultural diversity of the country. It protects the national cultural patrimony and assures its promotion. Article 47. The right to health and to a secure food supply is guaranteed. The law specifies the fundamental principles and the rules of organisation for public health and a secure food supply. Article 48. The right to decent housing. The right of access to drinking water and to electric energy are guaranteed. The law establishes the modalities of the exercise of these rights. Article 49. The elderly person and the handicapped person have the right to specific measures of protection concerning their physical, intellectual, and moral needs. The state has the duty to promote the presence of handicapped persons within national, provincial, and local institutions. An organic law determines the modalities of application of this right. Chapter 3 of Collective Rights. Article 50. The state protects the legitimate rights and interests of Congolese who are both inside and outside the country. Under reserve of reciprocity, any foreigner who finds himself illegally on the national territory enjoys the same rights and freedoms as a Congolese. Article 50. The state protects the legitimate rights and interests of Congolese who are both inside and outside the country. Under reserve of reciprocity, any foreigner who finds himself legally on the national territory enjoys the same rights and freedom as a Congolese, the political rights excepted. They benefit from the protection granted to persons and their assets under the conditions determined by the treaties and the laws. They are required to conform to the laws and regulations of the Republic. Article 51. The state has the duty to assure and to promote the peaceful and harmonious coexistence of all the ethnic groups of the country. It assures equally the protection and the promotion of vulnerable groups and of all minorities. It sees to their development. Article 52. All Congolese have the right to peace and to security, both on the national as well as on the international level plan. No individual or group of individuals may use a part of the national territory as a base of operation for subversive or terrorist activities against the Congolese state or any other state. Article 53. All persons have the right to a healthy environment and one propitious for their integral development. They have the duty to defend it. The state sees to the protection of the environment and the health of the population. Article 54. The conditions for the construction of industrial plants, of facilities for storage, for the handling, the incineration, and for the removal of toxic, polluting, or radioactive waste produced by industrial units or workshops established on the national territory are established by the law. Any pollution or destruction resulting from an economic activity gives rise to compensation and/or to reparation. The law determines the nature of the compensatory measures and reparatory measures, as well as the modalities of their execution. Article 55. The transportation, the importation, the storage, the spilling, or the disposal in the internal waters or maritime spaces under national jurisdiction, or the release into the airspace of toxic, polluting, or radioactive waste, or of any other dangerous product, of foreign origin, provenance, or not, constitutes a crime punishable by the law. Article 56. Any act, any agreement, any convention, any arrangement, or any other act which has the consequence of depriving the nation or physical or moral persons of all or part of their means of existence drawn from their natural resources or their wealth is established without prejudice to the international provisions on economic crimes as the crime of pillage punishable by the law. Article 57. The acts referred to in the preceding article, as well as the attempt of them, whatever their modalities may be, if they are acts of a person invested with public authority, are punishable as infractions of high treason. Article 58. All Congolese have the right to enjoy the national wealth. The state has the duty to redistribute it equitably and to guarantee the right to development. Article 59. All Congolese have the right to enjoy the common patrimony of humanity. The state has the duty to facilitate the enjoyment of it. Article 60. The respect of the rights of man and of the fundamental freedoms consecrated in the Constitution is imposed on the public powers and on every person. Article 61. In no case, even when the state of siege or the state of urgency has been proclaimed in accordance with Article 85 and 86 of this Constitution, can there be derogation of the rights and fundamental principles enumerated as follows. 1. The right to life. 2. The prohibition of torture and of cruel, inhuman or degrading punishments or treatment. 3. The prohibition of slavery and of servitude. 4. The principle of the legality of infractions and of penalties. 5. The right to a defense and the right to recourse. 6. The prohibition of imprisonment for debts. 7. The freedom of thought, of conscience, and of religion.